to the Michigan Department of Corrections for 600 months to 1,200 months. That's 50 years to 100 years. And you were convicted of homicide, murder, second degree, punishable life to life. Do you recall that, sir? All right. On behalf of the people, are there any corrections, additions, deletions?
Your Honor, thank you. There are deletions from the body of the pre-sentence investigation report. I had an opportunity to speak to Mr. Austin by phone yesterday. I believe that all of these deletions will be by stipulation. Essentially, Your Honor, what we want the pre-sentence report to reflect is information that was essentially brought out during the trial. There are things included in the PSI with regards to witnesses that were not called to testify, so we're going to strike those from the report here today.
That makes sense. Can you identify those, please?
Yes, Your Honor. Beginning on page 3 of the body of the report under the agent's description of offense, the second paragraph begins with the words, on 1/21/21, police made contact with Darlene Williams. Does the court see that?
Yes.
That entire paragraph and the paragraph after it, beginning with Miss Williams reported, both of those paragraphs should be stricken by stipulation in their entirety.
So stipulated?
We have no objection to that, Your Honor, yes.
Court is striking those two paragraphs in their entirety.
Thank you, Your Honor. Your Honor, referring the court now to page 5, still under agent's description of offense. The second paragraph from the bottom, beginning with on 2/24/21, police made contact. Does the court see that?
Yes.
That entire paragraph will be stricken by stipulation.
So stipulated?
It is.
Lastly, Your Honor, turning the page 6, still under agent's description of offense. The second to last paragraph, starting with police contacted Matt Perfit. Does the court see that?
Yes.
That entire paragraph and the next paragraph, which is 2 sentences, both of those are stricken in their entirety by stipulation.
So stipulated?
That is correct.
Is striking all of that?
Thank you, Your Honor. With respect to the content of the pre-sentence report, the people have no further additions, corrections, or deletions. We do have challenges to 2 sentencing variables, but we can do that when the court discusses the guideline range.
Thank you. Are there any other corrections, additions, deletions on behalf of defendant?
Not as it relates to the factual content or to the narrative or to the body of the report, Your Honor. There was another issue that Mr. James wished me to bring up on his behalf as it relates to jail credit, if I may. He's currently credited with no credit because of the dead time issue, because he was on parole at the time. And I can find no statutory or case law that would support this position. Therefore, I don't feel that I can ethically make it myself. But Mr. James wishes me to bring this issue to the court's attention and preserve it, and I told him that I would do so on his behalf. And I believe his argument is that he was essentially ready to be off or discharged from parole, and he was kept on there for another month while this matter was being investigated but not yet charged, and he was charged with it the following month, and therefore he believes that he should be entitled to the credit that he has served while this case is pending because of that. Again, my reading of the statutory and case law does not support that, but he wished me to make that challenge on his own behalf, and I told him I would do so.
I know no situation, case law, or statute that provides for that on behalf of the people.
Your Honor, thank you. The defendant was on parole. He is not entitled to any jail credit, and there is no statute or case law that would support that position. We'd ask that that request be denied.
Request is denied.
And that is it from our perspective as it relates to the factual content or to the body of the report, Your Honor.
Thank you. And as to the guidelines on behalf of the people.
Thank you. With respect to the PRV, the prior record variable, we're satisfied that that's correctly scored. As it relates to the offense variable, we make 2 challenges, Your Honor. OB1 is currently scored at 0 points. OB1 is the variable that has aggravated use of a weapon. Your Honor, it's our position in this case that the people have presented extensive evidence that there was a homicidal event inside of the defendant's vehicle. We presented evidence that there was a defect in both the molding and the metal door consistent with a bullet strike that was then forensically tested, and that was consistent with the finding of lead and copper for a bullet strike to that location. That in and of itself, we believe, would justify that this should score for aggravated use of a weapon, the mechanism of injury being gunshot. It's important to also note that the defendant in his testimony indicated that that was the mechanism of death. He testified that the victim was shot with a gun in the front seat of his car, in the passenger seat. What the defendant did was shift the identification of the perpetrator, but again, the mechanism gunshot is by the defendant's own admission. So we believe that 25 points is appropriately scored for OV number 1 for discharge. A firearm was discharged at or towards a human being. The record should reflect, Your Honor, as to the next variable, OV2, we are not asking that that be scored because there was no testimony as to the actual type of weapon that was used. So OV1, we're asking 25 points aggravated use of a weapon.
Response?
Yes, Your Honor, thank you. We would be opposing that, and we believe that it's correctly scored as it is. Of course, due to the particular nature of this type of homicide, there was no specific allegation in the information as to the type of instrument or to the type of act that would have occurred that caused this particular homicide. Now, I understand that that's due to the nature of this particular homicide and that there was not a body that was recovered. We did not have the traditional testimony from a medical examiner who could testify as to what instrumentation, if any, was the cause of death and so forth. Nor was such a finding required for the jury to find Mr. James guilty beyond a reasonable doubt of the charge that he was ultimately convicted of. We don't have any testimony or evidence of a particular weapon or firearm that was recovered or that was believed to be used in the homicide. And as it relates to Mr. James' testimony, or as the people refer to it as an admission, again, I think it's important to note that Mr. James was not testifying from his own observations or what he personally witnessed. He was relaying what was conveyed to him. So I am opposing that particular variable scoring, and I believe it should remain as is.
It is 25. I heard testimony and evidence, the bullet hole, the vehicle, and I'm adopting as my own the rationale of the people. OV1 is 25.
Thank you, Your Honor. Our last challenge to the offense variables is OV19, threat to security of penal institution or interference with the administration of justice. It is currently scored at 0 points. We are requesting that this be scored for 10 points for the offender otherwise interfering with or attempting to interfere with the administration of justice directly or indirectly violating a personal protection order. Your Honor, in this case, the record is rife with the defendant's interference with the administration of justice. Even if we look at the conduct of lying to the police in multiple interviews and misleading the police in multiple interviews, and even if we simply look at cleaning up the vehicle to remove bloodstains from it to deter police in their investigation, that would sufficiently score 10 points for OV19. But understanding that the jury found this defendant culpable, guilty for this homicide, getting rid of Mr. Watson's body would be the ultimate act of interference with the administration of justice. So for those reasons, we ask that 10 points be scored for OV19, Your Honor.
Response?
Your Honor, I'm opposing that request, and I believe it's properly scored where it is. Certainly, the Department of Corrections in preparing this report would have been familiar, I think, with the facts as they were presented at trial, or the facts as alleged in the initial police reports for this case, and they saw fit to score it at 0. And I don't believe that the evidence or testimony presented would warrant the scoring for that. So I am opposing it, and I believe it should be correctly scored at 0 where it is.
This is a no-body homicide. There has been interference. Again, I adopt the rationale of the people, as well as what I saw, heard, and didn't see. OV19 is properly scored at 10.
Your Honor, thank you. That will change the currently scored offense variable range from 65 to 100. That will ultimately change the range from an F2 to an F3. F3 range, Your Honor, would be 365 months to 600 months on the minimum, or a minimum range of 30 to 50 years.
Thank you. Any other corrections, additions, deletions?
No, Your Honor, thank you.
None for the people, thank you.
Thank you. Do we have any victim who wishes to speak on behalf of the decedent?
Your Honor, yes, thank you. We do have two victims who wish to address the court. They would like to come to the podium together if that's possible.
That's possible. If they can approach the podium.
Your Honor, let me introduce the victims who will be speaking first. Antoinette, Antoinett Watson, who is Andrew Watson's sister, will be speaking. And Otelia, Otelia Watson, Andrew Watson's mother, will also be addressing the court. They're approaching the podium at this time.
Thank you. Thank you both for being here. I know it's been a long journey, a tough road. I hate to do this, but I need to do this. Please raise your right hands. Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. If you could just identify for the record, the council already spelled your name, so okay, we do that, but tell me who each of you is.
Antoinette. Antoinette Watson. Otelia Watson.
It's okay, ma'am, I always speak for my kids. All right, so please speak into the microphone. We can bend it a little lower for each of you if you wish, or put it closer to you, and take your time. What would you like me to know?
First, I appreciate this court. I appreciate you, the prosecutors, for all you've done. To get justice for my son and our family. But for Willie James, I just hope he rests in here where he should be. Because there's no reason. I never thought about killing a person, but what's the purpose of throwing their body up? That's not just hurting that person, you're hurting the whole family. Because now we don't have that closure of burying my son. And he knows exactly where his body is. And he's had over 5 years to tell us that. But you got to be a really evil person to think that's not relevant. Or if they don't have a body, then they can't prosecute me. And then they turn everything around in the end. He could have told everything he said this year, he could have said it in 2021. He could have told us where the body was when we was looking for the body, when we didn't even know my son was deceased. So I just think he's a really evil person. And I hope he gets everything that he deserves. Because he do not deserve to be a free man, to walk the streets in the city that we live in. Because I've never heard nobody say nothing good or positive on his behalf ever, especially in the past 5 years. I never met a person like that. Never want to meet a person like that. So he can rest with his father Satan for the rest of his life and after.
I appreciate you being here. I can't imagine as a mother going through this. And that closure is so important regardless of how we lose our loved one. To say goodbye is your absolute right. You were there when he was born, and you should be there to say goodbye. I wish I could bring your son back. I wish we knew where he was. Can't grant you that wish, but I will take care of this.
Thank you.
You have honored your son, and you know, when we die, we leave our bodies anyway. So I know he's with you and your family. I'm sure you hear him, you hear his laughter, you cook his favorite meals, and you see him sitting with you.
Always.
Yeah. Well, he's here with you now too, man. What would you like me to know?
We should be in Vegas at a poker tournament somewhere right now. Think about it. Was the young man who needed a ride to school. He was that. He had his flaws, but he didn't have that for the other young men. I know young men who graduated because he helped got to school. in church. There's other people who, I just don't want that for other younger people. Um, I don't know what to say, but I'll just say, I hope that there's any fraction of decency in things like that. It's something that's gonna have time to sit and think about it, that he will really get that information. So, something about needs. That's all I have. I'm dressed in black for a purpose. This is supposed to seem patch or fashion for him. So I'm like, I can't even say good morning because it's good morning, but it's not a good morning.
Certainly is a day of mourning, but closure, not a funeral, but closure. So you've honored him. I hope that you will celebrate his life. Even if it's just having lunch or dinner, passing around gambling chip in his honor, whatever his favorite game was, because he's sitting there with you. And I think he deserves his life and legacy to be honored. Funerals are great. They give us closure. But you can have closure by a celebration of his wonderful life and all of your memories and sharing that. And I hope that you do that. I doubt that defendant will ever have the courage to reveal where the body is. Because it's only a weak man who kills another.
Yes. I feel like that he was in my son's shadow. He could never shine as long as my son was around. So in his devious mind, he thought maybe if I get rid of him, then I can be on top. I can shine. He's still in his shadow.
And always will be. You don't take care of disputes by a gun. You talk, you take positive action, and rise above. He went below. It is your son now, your brother, who's raised, is sitting with God and with you. I want you to always remember that. I know it doesn't give us a lot of peace because they're not there to hug and to celebrate with, but God has your back and has him sitting next to him, watching all of you. And I hope that brings you some peace because I know your family trusts in God. I don't know why this happened, but maybe it's to have brought the community together to show that guns don't solve anything, that you'll spend a lifetime behind bars. You pull the trigger, your life is over. Appreciate your strength and your words.
Thank you. Thank you.
Thank you.
Bring the defendant back up to the podium, Your Honor.
On behalf of the people, what would you like me to know?
Your Honor, first, on behalf of the people, we are asking that restitution be ordered in this case, payable to Utilia Watson and Andrew Watson Sr. We are asking that the amount of that restitution be held in abeyance pending the cost of funeral or celebration of life, as the pre-sentence report indicates. They have been waiting to conduct those services based on the outcome of the criminal trial. So we'd ask that restitution be ordered and that the amount be held in abeyance. We can submit any receipts to the court as necessary. Your Honor, when we listen to these compelling words from the victim's family, from his mother, from his sister, about the tragic loss of their son and their brother, and the devastation that loss caused the Watson family, there really is not much more emotional content that the people can provide to this court. And you, Your Honor, are left with a sort of cold legal decision to impose sentence based upon the applicable sentencing factors, or what we refer to as the SNO factors, which are rehabilitation, punishment, deterrence, and protection of this community. So we want to kind of walk the court through our position on those relevant SNO factors. As it relates to rehabilitation, Your Honor, looking first at this problem, this defendant, Your Honor, he has no legitimate rehabilitative potential. At 57 years old, this defendant has now amassed his 17th criminal conviction, 10 felonies and 7 misdemeanors. 2 of those felonies are for murder. The defendant has served 2 lengthy terms in the Department of Corrections, and neither of them have rehabilitated him or educated him or helped him develop any empathy or deterred him from his antisocial and violent homicidal behavior. And as we consider the next 3 prongs sort of together, it's important that this court understand that this defendant is dangerous, he is antisocial, he is repeatedly homicidal. He began his criminal record in 1991 when he was charged with felonious assault and then ultimately convicted by jury of aggravated assault. His violent behavior began to escalate, and it turned homicidal in 1998 when this defendant was convicted in another state of second-degree murder and second-degree assault with a dangerous weapon. And we ask this court to consider for a moment, Your Honor, what does it mean when a defendant has murdered not just one person in his lifetime, but 2 people? A defendant who has already served a 10-year commitment in the Department of Corrections for murder in another state, then waits another 10 years and murders somebody in our community. I want you to think about that. Most people go through their life, Your Honor, managing not to murder anyone, let alone 2 people. And if they have the good fortune to be released and to get out of one murder conviction after a lengthy term of incarceration to come back into our community and commit another homicide, that indicates to us, Your Honor, that this is an unrehabilitatable, violent, and homicidal individual that stands before you. In fact, in 2018, this defendant was convicted of assault with intent to do great bodily harm and felony firearm in connection with shooting his girlfriend. Your Honor, he served another lengthy prison term in the Michigan Department of Corrections, and he was on parole at the time he murdered Andrew Watson. Think about that for a moment. And that then leads us to the instant offense. We want the court to consider some of the facts of this case. Consider, Your Honor, how much blood was inside of that vehicle. Blood that had soaked into the seats and all the way down into the rails of the front passenger seat. Blood that had soaked into the back carpet so densely that the defendant had to remove that carpet to avoid detection. Blood that was so soaked and throughout that vehicle even after 2 professional cleanings. And what does that tell us, Your Honor? That this is a massive homicidal, lethal event that this defendant with a prior murder conviction perpetrated on this man inside of his car. And after that, Your Honor, as Ms. Watson so accurately said here today, the defendant then disposed of Andrew Watson's body. And we want you to think about for a moment, Your Honor, consider what it means to actually dispose of a whole human being. We have cases pending that have gone through the Ingham County Circuit Court in the last month where we see what happens when people are caught disposing of bodies. We see what that really looks like. But just because we don't have Andrew's remains, don't forget what that means to dispose of a whole human being such that he has vanished off the face of the earth for 5 years after an intense investigation. So this defendant is violent, he is homicidal, he is antisocial, he is an extreme risk of danger to our community. To deter this conduct, to protect others from this repeat offender, the defendant must be sentenced to a lengthy term in the Michigan Department of Corrections. Given the defendant's age, Your Honor, his parole status, it is the people's position that the defendant should be sentenced to a term of incarceration in the Michigan Department of Corrections of no less than 35 years on the minimum sentence. And that again takes into consideration his age. If he was 20 years old, we'd be asking for every day of 50 years. But given his age, at least 35 years in the Michigan Department of Corrections will ensure that he remains there essentially for the rest of his natural life. Thank you.
Counsel?
Thank you, Your Honor. Your Honor, the jury heard extensive evidence and testimony at this trial presented by the people. The jury heard testimony from Mr. James. He had his day in court. He was able to tell his side of the story to the jury. The jury rendered a verdict against Mr. James. We have to respect that. Mr. James maintains his innocence, as is his right. Yeah, I would note that Mr. James' statement in the pre-sentence report appears to be consistent with his trial testimony. jury found that this was not an act of premeditation. The pre-sentence investigation report writer indicated that they found Mr. James to be polite and cooperative during his interview with them. And I would note that that largely mirrors my interactions with Mr. James as I've worked with him on this case over the last few years. Nearly any sentence the court can impose is likely to have the same effect, Your Honor, in that it is effectively going to be a life sentence for Mr. James. I would ask the court to consider he has been incarcerated for a considerable amount of time while this case is pending without the benefit of accumulating credit for that because the law does not permit that. The Department of Corrections in the pre-sentence investigation report had recommended a sentence near the bottom tier of the guidelines as they calculated them to be. The Department of Corrections, of course, routinely prepares these reports. They are well aware of the facts of this case and Mr. James's prior criminal history, and they took all of those factors into consideration in crafting the recommendation that they did. I would ask the court to not exceed what the Department of Corrections recommended as an appropriate minimum sentence for Mr. James, and I would ask the court to sentence him, to consider sentencing him near the bottom end of his guidelines. Thank you.
Anything you want me to know, sir?
Say my version of the miss.
I can't hear.
Gave my version of the misunderstanding. See what's more.
Your history says it all, as does these actions, as does the mountain of evidence against you, sir. While you maintain your innocence, it is not to be believed. It is incredible testimony, as we say, which is not to be believed. The amount of blood, the amount of effort you went through to hide your crime is something this court rarely sees. And I've seen a lot. And I've seen people try to hide a lot of things. But what you did, tossing away evidence that fortunately was found and turned over, cleaning the cart, not once, but twice, disposing of an entire human being without a trace, that takes some planning and a forethought. That takes some knowledge. You have the history that shows that you have worked up to this crime, that you're not really being rehabilitated. That instead of talking, you use a gun. Your second homicide. And in between that, a lot of violent crimes. You haven't learned your lesson. This court does not believe that you will ever be rehabilitated in this lifetime. The sentence that I am going to impose speaks to the punishment and lack of rehabilitation. It also speaks to the community, who I hope is deterred from using weapons, who I hope is promoted and prompted to speak together calmly when there's a dispute, rather than getting into fisticuffs, violence, and the firing of a gun. We cannot tolerate any more gun violence in this community over anything, unless it's self-defense, and there is absolutely no evidence that what you did was done in self-defense. And if it would have been done in self-defense, you dial 911, you know how to do that. And you call police and let them do their investigation. But what you did is you hid the evidence because it was against you. You tried to clean it up and you hid the body from the family. I hope that in the years that come, as you are locked up, you find it in your heart to reveal to the family where their loved one is. They deserve that. And it is only a cold-hearted, inhumane person who will continue to hide their loved one from them. In order to protect society, we absolutely must keep our communities safe. by making sure that your antisocial behavior, the violence, you are kept behind bars. I am remanding you, sir, to the Michigan Department of Corrections for 600 months to 1,200 months. That's 50 years to 100 years. I believe that is proportional to the homicide, to the hiding of the body, to the long-term criminal mindset that you've had that continues not to diminish, but to escalate. There's no credit because you were on parole. You will pay a crime victims assessment amount of $130. And waiving fines, costs, attorney fees because you are indigent. You'll pay a $68 state cost, and I'm holding in advance the cost of the funeral and or celebration of life. And that money will be paid to Andrew and Otella Watson, his parents. They deserve at a minimum that. While you are incarcerated, you should go through cognitive behavioral treatment. You should go through mental health treatment and any other treatment for the antisocial behavior so that in prison you don't cause someone else harm. Is there anything I failed to address on behalf of the people?
Nothing for the people, thank you, Your Honor.
On behalf of your client?
No, Your Honor, thank you.
You have 42 days to appeal and to request appellate counsel. Counsel, please answer these appellate rights.
Your Honor, I have a notice of appellate rights form that has been filled out and signed by Mr. James. We would ask if the court could accept that for filing.
My clerk will accept that, get that filed, and you'll have your appellate counsel. The next judge you see will be the higher one than me.
Thank you,
That's
Your
all
Honor.
for the record.
Thank you.
Under Michigan law, the defendant was convicted of homicide and sentenced within the statutory framework governed by Michigan compiled laws, specifically applying sentencing principles under MCL 777 sentencing guidelines and related provisions. The court considered offense variables, including interference with the administration of justice, which increased the guideline range. The denial of jail credit was based on the defendant's parole status at the time of the offense, consistent with Michigan law that prohibits credit for time served while on parole detainer. The sentence imposed 600 to 1,200 months, 50 to 100 years, falls within the adjusted guideline range and reflects the court's finding of aggravating factors, including prior violent felony convictions and the nature of the offense. The court determined that the defendant presents a continuing danger to society and lacks rehabilitative potential, justifying a lengthy term of incarceration under proportionality standards. Restitution was ordered pursuant to Michigan victim rights statutes, with costs related to funeral or memorial services held in abeyance pending determination. The defendant retains appellate rights, including filing an appeal within the statutory 2-day period. This disposition reflects a guideline-compliant sentence emphasizing public safety, deterrence, and proportional punishment under Michigan criminal law.